is now in session. God save the United States of America, the state of Tennessee, and this honorable court.
Thank you, Mr. Hivner, and good morning, Miss Massey and Miss Turner. We're glad to welcome you to this oral argument today, which is being live streamed. We will conduct the hearing today in the same fashion as if we were all together in the Supreme Court room, and the appellant and the appellee each get 15 minutes. Of course, Ms. Massey, as the appellant, has the right to reserve up to 5 minutes, and I understand you've already indicated how much you wish to reserve. Unless there are any announcements, we'll ask Mr. Hivner to call the case.
Antonio Maurice Wiggins versus Carol Ann Wiggins.
Ms. Massey.
Good morning, Your Honors. Good morning, Judge Clement, Judge McBrayer, Judge Bennett. Happy to be with you here today. May it please the court, as you know, my name is Sharon Massey. I'm with the Montgomery County Bar, and I represent Antonio Maurice Wiggins in this appeal of the divorce decision from the Montgomery County Circuit Court by the Honorable Ted A. Crozier, Jr. The major contention today with our appeal is the award of the Alimony in Futuro Award to Mrs. Wiggins, and also the Alimony in Solito Award of $7,500 to her for her attorney's fees. As I'm sure you all have read the case, and I'll just briefly tell you that the facts of this situation are that the parties were married at the time of the divorce about 15 years, 9 months. And they are 50 and 49 years old, respectively. Mr. Wiggins is a G5 employee, civil servant, having served in the military for 26 years. Ms. Wiggins was also a civil servant in a contract position at Fort Campbell. Both of them were working at Fort Campbell at the time of the divorce. And the major issue, as I stated, is the award of the Alimony in Futuro. The standard of review in this matter is an abuse of discretion, and it is our position that there was an abuse of discretion. While the court applied the correct legal standard with regard to the alimony and an application of the factors, it's our position that the court reached a decision that was not reasonable, and the result caused what we consider to be an erroneous assessment of the evidence. In the evidence, specifically, the court awarded her $650 per month in transitional alimony, $700 in alimony in futuro, and $7,500 in alimony in solito. It is our position that based on the factors that the court misapplied some of the proof. For example, Mrs. Wiggins had an income, a monthly income of about $4,497.72, although in her income and expense statements that she filed, she listed her income only as $3,861.04 because she did not consider the 401k contribution from her employer as part of her income, although the court did say, yes, that is part of your income. Mr. Wiggins, however, his income was earned largely prior to the marriage. As I said, this is a 26-year military career for which he was compensated with retirement and also VA compensation. So she received a portion of his regular retirement, none of the VA compensation. He received approximately $9,000 per month in total, but his actual income from his employment was only at $2,800 and some odd dollars, whereas hers was, if you believe that her 401k contribution is not part of it, is $3,861, and if you believe that the 401k contribution by her employer, then she was making about $4,500 per month. She received approximately 18.43% of his military retirement, which garnered her about $520 per month additional income. It's our position that when she filed her income and expense statements, they were largely inflated. They had some amounts for things like the pool, which she was not going to be paying for, a car payment of $728 additional, which she testified herself that the car wasn't operable, or that it was in the middle of a lawsuit. She wasn't driving it. She also provided for her adult daughter. She was paying for a car for her. So when we take her income and expense statements and we reduce it by those amounts that she shouldn't have received credit for, then she doesn't have a need as great as what the court awarded her. We also would submit that we're not disputing that she may have needed some transitional alimony, and that transitional alimony was appropriate. When there are 4 types of alimony, and the court gives direction on when a person needs long-term alimony in futuro, this lady is not the kind of person that it's intended for in our position. She has an employment. She earns a good living. She earns $50,000 to $60,000 per year. And the fact that she needed insurance is not a reason simply to give somebody alimony for life. I'll also submit to your honors that her need is not as great as what she complains that it is. And I would also bring out the fact that in the evaluation of the factors, that the court seems to use the alimony as punitive in nature. And in reading the case law, the courts have said that this is not the intent of alimony, to punish someone. Mr. Wiggins admitted he had some indiscretions, and in fact the court made a comment, "I'm surprised this marriage lasted as long as it did, based on the problems in the marriage over the years." And so the court makes several statements that indicate that he is punishing Mr. Wiggins for his indiscretions. For example, he says that his fault is what caused it. She wouldn't need insurance if it wasn't for you. He makes several statements, and I listed those in the brief. And I would submit to your honor, while the only overlap to her having the insurance was 9 years. Mr. Wiggins had 9 years in the military, and what the court is talking about is the TRICARE, the military insurance for spouses and active duty and retired personnel. And so while having that kind of insurance is a lofty goal, when a person marries somebody that has good insurance, doesn't mean that necessarily in the event of a divorce, that person gets to keep it. Same as in, I know that you all say the name Gonswecki. I call it Gonswecki. I don't know what everybody else calls it. It's always something different. But in that case, the court said, while post-divorce having the same level of income or lifestyle is a lofty goal, it's not always a guarantee. And I would submit to your honor that also applies when you're talking about people who have insurance. It's not always possible to keep that level of insurance. She does have insurance available to her, and based on our assessment of what her income and her needs are, she should be able to provide that for herself. And
so you're saying there was proof in the record then about cost of different types of health insurance that were available to Mrs. Wiggins?
Not proof as in physical paper proof. I think she testified that her office offered it for $500, and that she had checked into other places, and it would range somewhere between $600 and $1,300 per month, depending on which type you got. Her issue was she wanted to keep the level of insurance that she had, which, there's no dispute that the military has and the federal government has good insurance. But she also worked for the military. She also worked for civil service, and they do provide good insurance. And so there was some proof in that there were different levels. I think the lowest one was $500. The highest one was about maybe $1,000, $1,200. Yes.
And was there proof about what the deductibles would be at those various levels?
Yes, sir.
Okay.
She did provide proof that the deductibles would be higher. Yes, that's true. She did. So it's our position that under the factors and the court, it appears the court gave great weight to the fault factor, and for the most part, the rest of them were the fact that he made more money, which I would submit to your honors that he earned more money from his military service prior to, and that was equalized with her receiving her 18.43%.
Well, Miss Massey,
Yeah.
I hear what you're saying, but my notes here indicate that husband's monthly income was approximately $9,200 a month, while wife's was $4,800, or it might be $5,300 based upon your other math, but that's a significant discrepancy.
It is a significant discrepancy, Your Honor, but I don't think that a person automatically gets to be raised to the level that the other party is. Just because one spouse earns more doesn't necessarily mean that you give someone money in addition to.
Well, $700 a month would not come close to raising her to the husband's income, and much of that is going to be needed for her health insurance.
Well, yes, Your Honor, that's correct. However, she also receives another $518, and yes, it's about $3,500 difference, and that happens to be the exact amount of his VA payments, which were earned largely prior to the marriage. I believe it appears that the court is attempting to get her to the level of what she was pre-divorce, and post-divorce give her extra money, but her need doesn't show that she needs that much money. That the amount that she is earning and the amount that she receives in his retirement should cover the amount that she needs. And then there was the transitional alimony of $650 per month that also raised her income for 3 years, which seems to be appropriate in light of her income abilities. So for those reasons, Your Honors, we would ask that the court reverse the amount of the alimony in futuro and also the award of alimony in solito.
Thank you, Ms. Massey, and we'll hear from you again on rebuttal. Ms. Turner, the floor is yours.
Thank you, Your Honors. Good morning. I'm Kimberly Turner from the Montgomery County Bar, and it's a pleasure to appear before you gentlemen today. A bit different with this computer situation, so I'm going to do the best I can here, guys. I wanted to go over exactly what the court did find. The court found that my client, Ms. Wiggins, who is now 50 years old, was 49 at the time, had a need for alimony in futuro, and that need for alimony in futuro was based on her need for health insurance. The health insurance that she was losing as a result of this divorce. She did have insurance available through her employer, through the Department of Defense. However, she testified that that insurance would cost $500 and change. Now, whether that was $590 or $530, we don't know. But she also testified that her job was a contract position that was subject to renewal annually, that it may not be renewed. Had the wife taken that particular insurance, she may not have had it the next year. So then she offered, and it was entered as Exhibit 6, information from the marketplace about multiple quotes. And those quotes included a range of $630. And this was an insurance which had a deductible, I believe it was of $5,000. And the highest insurance was $1,130 and had a much lower deductible. She didn't ask for $1,130 worth of insurance. She asked for $700 so that she would be able to obtain health insurance, hopefully optical and dental as well. She testified that through COBRA, the military would provide her with insurance for 3 years at the rate of $600 a month. At $600 a month, she also had insurance, optical insurance at $19 she'd already taken out. So we're looking at $619 if she went with the COBRA. Then she wanted to get the dental insurance. And the testimony there wasn't a testimony about the amount for the dental insurance. However, the husband's LES indicated he was spending about $50 a month for dental insurance. So $700 to cover the COBRA and to cover dental and optical insurance is absolutely not a ridiculous amount. Now, this was only for 3 years. After that, this was going to increase. In the marketplace, the least insurance price you could have gotten with a super high deductible was $630. You add into that the additional $19 for the optical insurance plus the cost for dental insurance. And again, $700 is not some terrible price to request. Again, she wasn't trying to be greedy. She simply wants to keep her health insurance. Now, the defense would, the husband would argue that this was punitive, but it was not punitive. It was equitable. And this insurance that she'd had was not for 10 years with the military. While he was in the military, they'd been married for 16 years, and she'd had TRICARE for 16 years. He had retired 6 years earlier, but he had had the TRICARE the entire time that they'd been married. Now, she worked during the marriage. She had insurance available through contract employees or through contract work, but she had not taken that because she'd always had stable insurance through the military. Because the husband cheated, and it wasn't an indiscretion, there were 3 indiscretions. There was 2005, 2010, and the last one when he went to the Dominican Republic in 2018 with a coworker that he had an affair with. The wife had forgiven, taken him back. The wife didn't want the divorce. And that came out in the actual testimony, that she would have probably taken him back again, except he moved out and filed for divorce. In this case, alimony in futuro is absolutely appropriate. She doesn't have a steady guarantee of insurance through her employer. She does have it available through the marketplace. But if you look at her income and expense statement, without the supplement from the husband, she doesn't have the ability to afford the basic insurance that she needs. Even the one with the $5,000 or the $3,000 deductible is beyond her reach. Not only was this divorce taking away the home and the I believe you'll hear about the sanctuary, her pool, and the standard of living was excellent. Not only was she losing all of that, but she was losing something she absolutely needed. At 50 years old, we start falling apart. Things start happening. And losing insurance at 50 years old, that's a big deal. The court did take that into consideration. The husband caused the demise of the marriage, and the courts can consider the husband's causing the demise of the marriage when they award alimony. In this case, the court was correct to award alimony in futuro in the amount of $700 a month. The next thing that the court ordered—
Ms. Turner, if I
Yes, sir.
may stop you, it does appear that the trial judge repeatedly stated because the divorce is the husband's fault, or thus it's the divorce was at fault, the husband was at fault for wife's predicament. And then it talks about that in the, that's in the alimony in futuro. And then he mentions fault again in alimony in solito. To what extent is fault appropriate to consider in alimony?
Your Honor, I think that the court can consider the fault of the party who is causing a significant loss to another party. I don't think that in this case the court made that its predominant consideration, but I do think it was something he considered. He also considered the lack of education for my client. My client had graduated high school, and I think she may have had a little bit of college, but the husband had a bachelor's degree. He'd had 26 years in the military. He had done well, and he had a VA disability. He had a retirement, and those were earned partially during the marriage. And then he had this job that he has now, and he's earning a new retirement. He's earning almost $3,000 a month. I believe the exact number of his income is $28.15 for his military pension, $500 and actually $10. $510 was going to go to the wife. Of that, she'd be taxed, and the testimony was she'd get about $460 out of that. Then his civil service job paid him $34,507 a year. I averaged that out to $28,7550 monthly. Now that was taxed, and then he received a VA disability of $3592.35, and that was non-taxed. So, and he's also earning another retirement. My client has no retirement because she had a contract position. That's all that was necessary during their marriage. If she loses that job, she doesn't have a retirement. She did have a 401k, and so did he. His 401k, I think, had $13,000 in it, and hers had $10,000 in it. So she had a 401k that she was working on building up, but she had no pension that she was going to receive as a result of her employment. Her total income, without including the contribution to her 401k by her employer, was $3,861. If you included the other, and the court did, the court said, well, it doesn't matter if it's going in hand, it's a contribution, and the court did increase the amount of her income that he considered. And I believe he changed it to $4,400 or $4,600. I don't have that number right here in front of me. While the court did consider the relative fault of the parties in this case as far as any award of alimony in futuro, the court also went on to consider the income. The court considered the earning capacity. The evidence supported that the husband's earning capacity was far greater than the wife's earning capacity. The court considered the duration of the marriage, the earning capacity, the training, the duration of the marriage, the fault, the fact that there weren't a whole lot of assets in this particular case, and there weren't. There was a house that was valued, I think, after the sale of the house with no closing costs, there was about $79,000 worth of equity. When you take away those closing costs, there's not a significant amount of equity left to divide. That was to be divided equally between the parties. But there simply wasn't a whole lot. Husband walks away with a huge income of $9,000, and the wife walks away with about half of that. So the court considered that. While it has the right to consider fault, it didn't solely consider fault, and I don't believe it considered fault as even a 50% of perspective here. There was not a preponderance of consideration to the fault. It was a conglomerative consideration of education, training, ability to earn, length of marriage, and assets. Next, Your Honors, we consider the transitional alimony. This is an absolutely appropriate case for transitional alimony. The wife had horses all during the marriage. The husband testified that he paid $375 a month for the wife's horses. After this divorce, the wife had to pay that herself. She said she had $300 in recreational expenses. But when you're showing horses and when you're participating in something that you've always done, it's expensive. But $300, you go out to dinner and you can spend $300. Go out to dinner, you're looking at $50 or $60. You go to a movie, and if you buy popcorn and a drink, you're looking at another $40 or $50. So $300 for recreation when you're riding horses and showing horses is not an extravagance. The wife did not include in her income and expense her makeup. And if anybody's married, they know what makeup costs. The lawn care and the closing and opening of the pool. Your Honor, she didn't put lawn care back into her last income and expense statement. She took out the entire $122. So the wife's expenses were absolutely not exorbitant. The husband complains that the wife said she was, that the wife inflated her expenses, but in the husband's brief, they leave off the wife's laundry and dry cleaning of $100. The husband's was $60, so the wife's at $100 is not unreasonable. They leave off the beauty and barber. The wife's was $200 a month, but the husband's a man at $86.66 a month. So for a man to spend $86 a month to keep his hair done and a woman to do her nails and hair at $200 is pretty dadgum good. Then we get into the cost of the Jeep. The wife did not testify that the Jeep did not run. If you look at actually, I don't have the transcript page number, but in the transcript, she testified that the Jeep, page 110 of the transcript, lines 1 through 3, she testified the Jeep runs, but 10 through 15, she says she hadn't got rid of it because it's tied up in a lemon law lawsuit. So she was paying for this vehicle. It's a lemon and she can't sell it, and it's in the middle of a lawsuit. So that's an expense she has to pay. Now, the court didn't give the wife a lot of consideration for that. And he said, you're paying for this Jeep. I'm not giving you $1,000 a month in alimony, transitional alimony. I'm only going to give you $650. Well, she couldn't dump this Jeep because it's in a lawsuit. She had to continue to pay for it. The Jeep was something that was also left out of the statement that the wife's expenses were inflated. She also had to pay $60 for prescription drugs and copays. And if she goes to one of those plans that's going to be a $3,000 deductible and less coverage than TRICARE offered her, she's going to pay a whole lot more than that. So the wife's expenses were not inflated. They include electricity of $120 a month. Well, good luck with that. A phone of $155, that's not inflated. Food, $500. Well, that's not inflated when you consider the husband says he eats $300, but in his income and expense statement, he adds back another $150 or $125 under general expenses and says that's for groceries. Well, he doesn't have to buy makeup and hairspray and all of those things. So the wife's expenses were minimal. The wife left off a lot of things she could have included. And I'm running out of time here, so I'm going to run to the alimony in Solido for the wife's attorney's fees. The wife had paid $7,500 in attorney's fees, $400 for mediation, and $100 for a counter complaint filing fee. She asked to be awarded that, and the court did award that, with the exception of the mediation fee and the filing fee. He did not give her that. He gave her $7,500. But the testimony was that the wife's attorney's fees that far had been $7,500. She had paid it out of her paycheck. She was on a payment plan. And oh, by the way, it didn't include the final hearing, the amount she was going to be charged for the final hearing. She was paid up to date, but still being charged for the final hearing. So the wife was not even awarded her entire attorney's fees. She was awarded $7,500. Alimony in Solido, in this case, evened out what the wife had to spend because she had to go through a divorce that she did not want to go through, and she had to use money to pay for it and would still have to use part of her income to pay for it in the future to finalize the cost for her attorney's fees. So it wasn't that she was just reimbursed entirely. She still had to continue paying. I don't recall how long this hearing lasted, but with me and Miss Massey going at it, it probably wasn't a short hearing. So there was significant attorney's fees still left to be paid. The court did not abuse its discretion. It made the correct factual findings. And if transitional alimony ever should have been awarded, this lady had to transition from a lifestyle she was accustomed to down to a lifestyle that met her income. And 3 years to do it with $650 to aid it is not unreasonable. If she can't keep paying for them horses in 3 years, well, see you later. But until then, she's got the opportunity to try.
Thank you, Ms. Turner. We'll hear from Ms. Massey in your rebuttal.
Thank you, Your Honor.
Ms. Massey,
Yes,
you're
sir.
not challenging the transitional alimony, are you?
No, sir, I'm not. I'm not questioning the transitional alimony. And in fact,
Okay, go ahead. I'm sorry.
it would be our position that even a little longer transition might be appropriate, or even, and this has been done, a rehabilitative, even though she doesn't need quite rehabilitation. But one of the factors that the trial court it listed was the fact that the wife had some college and that he had a bachelor's degree. Well, the income level between a bachelor's person and somebody that has a little bit of college is not great when you look at their employment. In fact, with her employment, her earning capacity with her job was actually more than his. Her income from the position is actually more than Mr. Wiggins. The only thing that causes his income to be more than hers is his VA disability and his retirement. And of course, the retirement is partly a property division. And it would also be, the court did not give great consideration to the fact that she was receiving a portion of the property. I also would point out that Mr. Wiggins received more of the debt, and that factor wasn't considered. He received the entire, they had agreed in mediation to equally divide the equity when the house sold, but he was obligated to pay the pool debt, which he did. But I would submit to Your Honor, there's no proof that she was losing that job or that her job was in jeopardy. A lot of ifs, in 2020, a lot of people stopped working, but the federal government people did not. And there was no proof whatsoever that she was losing or the contract was up. To say hypothetically, if someone might lose their job, I don't think that that can be considered here because she currently was employed and was making good money. I would also point out, Your Honors, that on her income and expense statement, when you remove the fluff that we considered, and I listed them on page 8 of our brief, her total expenses, including $500 for some part of insurance, was $4,079. Now, she was earning more than that, plus the 500 put her over earning 5,000 some odd dollars. I would just submit to Your Honors that the court did make a logical reasoning here and abused its discretion in ordering alimony in futuro in this particular case. And I would ask Your Honors to overturn that and reverse that decision. Thank you.
Thank you, Ms. Massey and Ms. Turner, for your arguments. We will take your case under advisement. Mr. Hibner?
Thank you.
Thank you.
This honorable court is now in recess until 10 a.m.